Start.
Yes, madam, please start.
Okay. Good afternoon, everyone. The present course on paper 1 will be dealt with the fundamentals of business law, which would include Indian Contracts Act, Sale of Goods, as well as Negotiable Instruments Act. In addition to it, we are going to read about the sources of law, legislative process, legal method, and the court systems in India, primary and subordinate legislations. And additionally, we are going to read about business communication, which talks about various other heads relating to the soft skills as well as the types of business communications that have been dealt with under this particular module. If we look at the first discussion, we begin our discussions with the contract law. The Indian Contract Act. What exactly is it meant by Indian Contract Act? When we talk about contracts, types of contracts, offers, and acceptance. We are going to talk about void and voidable agreements. We are going to talk about consideration in a contract. We will be talking about the legality of object and the legality of consideration, as well as capacity of the parties, the free consent involved therein, the quasi and the contingent contracts, performance contracts, indemnity, guarantee, pledge, agency, as well as e-contracts and e-signatures. Additionally, we are going to talk about discharge of contracts and breach of contracts and remedies for breach. When we are talking about contracts, what exactly is meant by contracts? Contracts as such are agreements which are lawfully enforceable under law. When we talk about any agreement for that matter, every agreement may not qualify as a contract. However, every contract qualifies as an agreement. The reasons why every agreement may not qualify as a contract, although we see a plethora of agreements which is being entered into by people with other entities on a daily basis, is because there are multiple agreements which lack the enforceability factor. The legally enforceable, the lawful enforcement of such agreements depends on multiple other components, which has been dealt with under the Indian Contract Act, such as the capacity of parties, the legality of object, the competence of the parties, as well as how a particular contract can be enforced vis-a-vis the other party in situations that there is a breach. Now let's look into the Indian Contract Act in details. The law relating to the general principles in the Indian Contract Act has been dealt with under section 1 to section 75. In addition to it, when we talk about what exactly are these general principles that have been mentioned within the Contract Act, they deal with starting with the concepts of what exactly is the definition of a contract, how exactly is an agreement defined, when and to whom a proposal or an offer is made, and when is that particular proposal or offer accepted, on what grounds that particular proposal or the acceptance of the same proposal be done, and on what grounds can it be made void or voidable. Now let's look at the basic concepts before we move forward with other more complex concepts. Section 2H of the Indian Contract Act defines the term contract, which says that any agreement between two or more parties which is enforceable by law would qualify as an agreement, a contract. Now, on a day-to-day basis, when a person is going out to various different places, whether I am traveling by the bus or you're booking an Uber for travel from one place to the next, or you are getting admitted to a university, or for that matter, if we are going to a hotel or a restaurant to eat food, all the situations, every situation which has been spoken under uh, any of these conditions would be considered as a contract. When the particular contract is being spoken about, the particular contract can be with the bus conductor, the bus owner. If we are booking a flight ticket, it could be with the company, the airline company. If we are going to the airport after buying a ticket, the fact that you give an airport charge, that qualifies as the fact that you are giving a certain part of your consideration, and vice versa, which is being done by the airports authority with respect to the usage of services at the airports. Similarly for railways. Under all of these conditions, if we see, all of these conditions talk about what we mean by a contract and how agreements on a day-to-day basis are made. Now, an agreement and its enforceability are two essential components of a particular contract, as has been rightly pointed out in the reading material. But if either of these two is missing, then the contract either becomes void ab initio, or it becomes void, or it becomes voidable. But voidable is always at the option of one of the parties. It's not the same case as the particular contract being void or void ab initio. Now, what do we mean by an offer? To constitute a contract, the first is what exactly precedes an agreement. Whenever a person has made an offer and that particular offer has been accepted, then with that particular exercise where an offer meets its respective approval or acceptance, that would lead to an agreement. Legality of the offer or acceptance made for the particular offer is very important to be looked into after we find out that there is an agreement in place. So section 2B defines what exactly is an offer. When the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted, and a proposal, when accepted, becomes a contract. Which is to say that whenever we talk about what exactly is a proposal, it is basically something which a person makes in order to gain the assent of the other person. And the moment he gets it, that would turn into an agreement. Say, supposing if I give you a pen and I say I am willing to sell you my pen for 10 rupees. When you say that no, I'm not going to offer you 10 rupees, I want to offer it for 9 rupees. I can very well say that fine, I will offer you, but not at 9 rupees, but at 9.5 rupees now. You think it's a good deal. So you say, I accept your offer for 9.5 rupees. Now, even though there has been a negotiation, the final offer of 9.5 rupees was made by me, the offerer, and that was made in order to seek the acceptance that you would give me in order to buy the pen. Now, whenever this give and take of an offer and an acceptance, corresponding acceptance takes place, that would now amount to an agreement being formed. The essence of this particular agreement is something which begins with the meeting of minds, which we also call as consensus ad idem. Whenever there is a particular contract, the fact that an agreement precedes a contract in all meaning and purpose, the idea is that when I give you an offer, I will make an offer thinking of a certain object in mind. You will accept the corresponding offer thinking of the same thing in mind. If you had something else in mind, and if you have assented to that, knowing fully well that that the assent that you are making is for the thing that you think is correct, in such cases there wouldn't be any meeting of minds. For example, if I was to say that I'm going to sell you my Bajaj Chetak, if I say that I'm going to sell you my Chetak, which is the scooter that I have. However, if you thought Chetak was the horse that I owned and you assented, you agreed to buying my Chetak, which is the horse, in such cases we are on two different pages and there is no acceptance to the offer that I've made because there is no meeting of minds. So, meeting of minds and the intention to create legal relationship is something that precedes any agreement and as a consequence any contract. Now, if you look into what exactly has been said, there is an example which the module also says about two cars which are being sold up for sale. But the problem was that the offer was made for one car, whereas the acceptance was made for a different car. Now, the fact is that in such cases, there wouldn't be any agreement because the acceptance has not met the offer. Now, do all agreements give rise to a contract? Is a very basic question that is at the heart of Indian Contract Act. Every agreement will only give rise to a contract, provided there are certain basic tenets that it fulfills. If you fulfill those basic tenets, only then will the judiciary ordain the status of a contract to the agreement that you have so made. So what exactly is it that defines an agreement or a contract as such, which is a bit different from an agreement? So the essentials to a very valid contract are a few in number. One of the first being offer and acceptance. The second being lawful consideration. What are you giving or receiving in lieu of the offer you have made or the acceptance you have made? The third, there should be free consent. I cannot put a gun to your head and ask you to sign the papers of selling the house. I cannot go to a particular religious head and just because of the power or the privilege, that influence that he enjoys in his disciples' life or his devotees' lives, I cannot ask him to go and say these things to his devotee that he should sell his house at a throwaway price, or for that matter, he should go and buy a particular property which belongs to an ex person in order to gain some profits. So a free consent can be vitiated by multiple factors, which we will be discussing in the due course, but a free consent is extremely important. The fourth is regarding the object of the agreement, the fact that it should be lawful. Every object for what is the contract or the agreement being entered into. Are we entering into a contract to murder somebody, to kill someone? What exactly is the reason for taking that particular, what do you say, making that particular offer and making a corresponding acceptance? So, free consent is extremely important, without which a contract can never be made. The fourth is the object, which has to be lawful in nature. What is the object that you are dealing in? If it is gambling, then it's opposed to certain countries' laws. If it is, with obviously with some exceptions, if it is not, what do you say? If it is not, uh, if it has not been done for a very lawful object, in such cases, it wouldn't. The agreement will fall short of being a legally valid agreement. So the contract has to be enforceable by law. That's a necessary precondition for the fact that you, as a person who's entering into contracts, is supposed to have certain rights and obligations and duties under a contract, and so will the other. Now, when we are talking about what exactly is the definition of a proposal or an offer, a proposal or an offer is basically when a person signifies to another his willingness to do or to abstain from doing to obtaining the assent of that particular other in to such act or abstinence, he is said to make a proposal. What is the purpose of me making the kind of what do you say uh, proposal? What am I seeking by making an offer to someone? How exactly do you think that offer would be reacted to or translated into, better still? So when we are talking about the ways in which a particular proposal or an offer is drafted, it says that when one person signifies to another. So I have made an offer for you to accept. If you don't accept, my offer would stand negated and there wouldn't be any contract. Similarly, section 2B talks about acceptance or promise, which says that when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. And the moment a proposal, when accepted, becomes ordained as such, it is something which is called a promise. So basically, the idea is that whenever we are talking about acceptance, it is the fact that the other person to whom the offer is being made has provided his assent. The third is with respect to who exactly is the person who's making the offer and who is the person who's actually accepting the offer, the offerer and the offeree. This has synonymously been used with the terms of promiser and promisee. So the person who's making the proposal is called the promiser, whereas the person to whom the proposal is made and the person who is going to accept it is the person who is a promisee. And similarly, consideration under section 2D has been spoken about, that when the promisee, the one who's accepting the agreement, decides to do something for the promiser, in such cases, the persons when as and when the assent comes, the person's offer becomes an agreement. This is what they have said about that the consideration is something that backs the particular contract. So, when at the desire of the promisor, Section 2D says the promisor or any other person has done or abstained from doing or does or abstains from doing a promise or promises to do it or to abstain from doing something which is an act or which could be an act or abstinence basically. A promise is called a consideration for the purpose. What exactly are you doing for the other person? Section 2E talks about what an agreement is. Now, if you see, all the sections over here are all jumbled up. But this was done possibly in order to streamline the discussions in the vocabulary alphabetical way. But if you see how it was done, Section 2E talks about what an agreement is, which we have already discussed, whereas Section 2F talks about reciprocal promises. And Section 2G talks about void agreements. And eventually they talk about voidable and void contracts. So the idea is that whenever we are talking about an agreement, every promise or every set of promises forming the consideration of each other in an agreement. For my promise, you have made a consideration through your promise. Similarly, my promise is going to be a consideration for your promise. So when we are talking about what an agreement is and how is an agreement dealt with, it's basically when an offer meets its corresponding acceptance and that there is a particular consideration and an object and minimum two parties to it. So section 2F talks about reciprocal promises, which I talked about when we were bargaining about the questions, etc. 9, 9.5, etc. However, section 2G talks about void agreement. An agreement which is not enforceable by law is said to be void. Any person whose entire promise requires somebody to do something, that's a reciprocal promise, whereas void is when it is absolutely not enforceable by law. Voidable contract and void contract, where voidable is a contract which can be stalled if you don't like the party to whom the particular agreement or the offer is being made to. So in such cases, if you read section 2F, section 2I, section 2J, talk about the kinds of contracts that there are. Essential and valid contract. Essential elements of a valid contract. The first is an agreement, the second is free consent, the third is lawful consideration, the fourth is parties are competent, fifth is the legality of the object, the sixth is legal relationship, the seventh is agreements which were not expressly declared to be void. Then you have the eighth agreement, which says consensus ad idem, where you have to meet the minds. Whereas the remaining talks about consensus ad idem, the certain and capable of performance test which is employed on the parties, and legal formalities. All of these are something which constitute a valid agreement. When we are talking about what are the certain and the capable performances, or the fact that consensus ad idem should be with the person to whom the offer has been made, then in that case, your frustration, the doctrine of frustration or the doctrine of impossibility doesn't come in between. Now, when we are talking about when we are talking about what exactly do we mean by certain and capable of performance, we talk about the fact that the parties are competent to perform, as well as the fact that the object of the contract is performable. And the legal formalities which talk about all the compliances of the formalities which have been mentioned within the particular agreement. Now, the parties have to be in a legal relationship, which basically means that if you talk about a person whose wife cooks for him, can we say that there is a contract between the wife and the husband? Now, through various rules, through various ways, we can prove that what the wife does is out of affection and love for the husband or the children, whichever whoever is involved, and based on which she is serving food. However, so there is no legal relationship, but the same husband and wife, if they were in a relationship where the wife would have asked the husband for maintenance of her upkeep or her upkeep, in such cases, the husband would have been liable under a legal relationship to pay to the wife, regardless of whether or not she cooks for him or cleans for him or does any work for him. So the whole idea is, what exactly is the legal relationship all about between both the parties to a particular contract? When we are talking about types of contract, one of the first types of contract is that which is based on enforceability. The second is based on formation. The third is based on the extent of performance, whereas the fourth is based on obligations. The other modes are based on mode of contract, implied or inferred contract, or e-contracts. So when we are talking about a type of contract, what exactly is something which the first thing that we say as something that is based on enforceability? In such cases, there are 6 types of contracts: valid contract, voidable contracts, void contract, as well as your unenforceable contracts and illegal contracts. A valid contract is where all the essentials are being met, and therefore it can be qualified as an agreement. Whereas a void agreement is either something which is ab initio or void which has become my operation of the in due course of time. So when we are talking about void agreements, it says that every agreement, if it does not fulfill the mere mandates of that particular country, or the mere mandates of that particular contract, in such cases, those contracts would fall short of being valid. Whereas void agreements are those whereby there is a breach or there is no knowledge of the other party with respect to a contract which is being performed. Now that amounts to the voidability. And then finally we talk about voidable contracts. Supposing if I had put a gun to your head and made you sign your house deeds in order to pay me, in order to make a payment, or in order to get the house on extremely meager payments. In such cases, would you think that there would be a valid contract just because I signed on those papers which were made to be signed by me after putting a gun to the head? So, through the judicial, precedents, if we see it, this sort of an exercise amounts to a voidable contract, whereby if one of the parties who has been subjected to such kinds of uh, incompetencies, in such cases they can, or something that falls short of fulfilling the contract, they can very well take it up with the particular uh, uh, courts and say that I choose to make the particular agreement voidable at my option. So such an option, when the parties have chosen, that is irreversible, and that is something which the parties itself can choose to opt out of a contract. So under no circumstances would a mere signature make the parties bound to fulfill the particular contract until the time that it is mutually agreed that the contract be put to rest. The next is with respect to based on method of formation. When we talk about what are the various methods of formation of a contract, it could be on a formal contracts basis, or with respect to the extent of the performance and based on obligations, or based on creation of charges. And finally, implied or inferred contract, or e-contracts. So based on the method of formation, a formal contract is a contract which is used in English law. So validity of these contracts depends on the various forms. So they had very valid, even and effectively running, even if the lack of considerations has happened in such contracts. These contracts are two types. Either they are contractual under the Contract Act and the seal and contracts, contract of records. The second is with respect to contract under seal are in writing and signed by the parties to them. And the contract of records includes the court judgments and recognizes obligations in such cases arise out of judgment and other and not under the contract. Now, simple contracts are those which are formally called simple contracts or parole contracts. Now, when we are talking about the based on extent of performance, executed contracts, as executed contract, it is one which has been completely complied with, completely completed by both the parties. And an executed contract is where a contract is wholly underperformed, whereas if one party has performed his part of obligations, but the other party has not yet completed his obligations, on the account, the contract still remains executory contract. So why do you think a particular contract has been made? Now, based on obligations, there are unilateral as well as bilateral and multilateral contract, and there are multiple parties to it. So under these sort of contracts, say in a unilateral, there is an obligation on the part of one party with respect to when the contract is concluded. The second is with respect to bilateral, where there is an obligation on both the parties to the particular contract. And finally, we talk about the multilateral contract, which says in a type of concession, type of contract, more than two parties are involved. These very complex contracts and generally take international character are the ones that we consider as multilateral contracts. Now, on the basis of creation, there are certain implied or inferred e-contract as well as express contracts. One of the other forms which has not been mentioned here is a standard form of contract. A standard form of contract is only supposed to be coming post supposing your I wouldn't say negotiation, but say post your buying tickets or buying goods from a very big conglomerate or from a very big, highly powerful, influential party. Supposing when we are buying railway tickets, railway doesn't have. There are so many people who are buying plane tickets on a daily basis. There are so many people who are buying railway tickets on a daily basis. So in such cases, when there is some such thing with respect to buying of tickets, at the end of the day, since they are also contracts, railways or airlines will not sit down with each and every party to negotiate a contract with them. Instead, they have a standard form of contract which either, if you like, you can take it, and some things that you don't like, you can leave it out. So it's take it or leave it basis which a standard form of contract works on. And then we have the e-contract, which says all the e-commerce interactions or every sort of buying and selling which is done through online portals is a part of e-contracts. So in such cases, in all of these cases, since there are margins involved, since there are agreements, various kinds of agreements involved, since there are people who enter into a contract on a day-to-day basis, but do not understand what sort of contracts they may be. They may be standard form, they may be normal contracts. In such cases, this is the way that we can distinguish. Now, when we are talking about offer and acceptance, what exactly is understood by offer and acceptance? The meaning and definition of offer and the types of offer has been described. Excuse me. So the meaning and definition of an offer talks about, for an agreement to come into force, there should be a defined offer, a definite offer by one party and an unqualified acceptance. The qualification here that has been spoken about talks about the various terms and conditions that your offer or an acceptance may be laden with. So if you talk about a particular acceptance of a particular contract, then in such cases, the qualification could be, I will agree to do something for you provided that in the next 7 years you do all of these for me. But the fact is that the object of the contract is immediately to be fulfilled. So there are many qualifications to an acceptance by the party to whom the offer is made, and therefore an offer is an expression of willingness to contract on certain terms made with the intention that it shall become binding as soon as its acceptance by the person to whom it is addressed, the offeree. Now, what is meant by express and implied offer, and what examples do we cite for them? Express and implied offer is where the offerer is making the offer. It could be in the form of an express offer, or it could be something of an implied offer. As a landlord of a particular house, I can tell my tenant that if I hear no more from you, I will expect that the contract has been renewed and you are bound to pay me 14,000 as rent. Now, unless the tenant wants to stay in that particular house, why else would he pay the 14,000 rupees at the end of the particular month? So in such cases, there are implied contracts also, such as this sort of a tenant landlord example. Whereas in express contracts, you talk about all sorts of things that you may give with respect to a promise that could be made. The offer and invitation to an offer again are two different concepts, which says that when you are making an offer, you're making a point blank offer based on which, if an acceptance is received, it entirely completes into an agreement. Whereas an invitation to an offer is where the offer has not yet been made, but an invite has been sent out to make an offer. So in such cases, the person who's offering is a different person than me, who is inviting the person to make an offer. Eventually, he can have his own acceptance when he makes an offer of his own. But the whole concept of invitation and offer or an offer is something which is premised on that. Now, offers can be specific, they can also be general. What else they can be is with respect to the rules regarding the offer. So, the rules regarding offer are the following with respect to the fact that the offer may be expressed or implied. The offer may be specific or general. The offer must give rise to legal obligations. There has to be a term of an offer, which must be definite and certain. The next is with respect to the offer must be distinguished as an invitation to an offer. Whereas sixth is offer must be communicated. The seventh is communication of special terms. Eighth is with respect to offer must be made with a view of obtaining the consent of the parties and to do so or to abstain from doing the act. And finally, they speak about offer should not impose an unnecessary obligation to communicate non-acceptance. An offer to make an offer is not an offer, and thereby they talk about the meaning and the definition of what an offer stands for. So whenever we are talking about what exactly is an offer and what are the components of a binding offer, there are multiple ways to put it. Now, when we are talking about a valid acceptance, they say that a valid acceptance can only be done when there is an absolute and unqualified acceptance and it is communicated. And similarly, it should be within a reasonable period. If somebody offers me a job today, I can't expect to go after 5 years and say a yes to the job, because by that time, because of influx of time, the job may have been offered to somebody else. So in such cases, the acceptance has to be within a reasonable time and preferably very prompt. The next is with respect to acceptance, which must be given within a reasonable time and before the offer lapses. And finally, acceptance cannot precede an offer, and acceptance must be given only by the person to whom the offer is being made. The fact that offers can also be rejected, but if there is an offer to be accepted, it can only be done after the renewal of the resignation, after the resignation has been done. And finally, acceptance is something which to give the acceptance. If I say that, okay, fine, I will reply to it, it doesn't mean that I'm always going to reply in the affirmative. Similarly, if I say, fine, I'll think about selling my phone, it doesn't mean that I have actually sold my phone or actually sitting somewhere to sell my phone. So, asking or inviting to make an offer or an acceptance qualifies as neither. So, the next point is about revocation. What do we mean by revocation of a particular contract? Revocation means to re-sign. You are going back on your promises or your acceptance and you say that you don't want to fulfill all the terms and conditions of the contract. So in such cases, if you look at section 5, they've spoken about revocation of the offer and acceptance. And eventually we bring in void and voidable agreements. What are void as well as voidable agreements? Void agreements or voidable agreements with no consideration or contract were actually looked down upon in the previous early years, but no longer so. In the present times, the idea is that even if that doesn't happen, the fact that a particular agreement will last until its death would also be very presumptuous. So, void agreements, voidable agreements, void contracts, voidable contracts, and imagine to add to it, we talk about voidable contracts in general. So, what sort of agreements may be declared to be void? So, if we look at section 11, 12, 23, 20 for that matter, 24, 25, 26, even 27 and 28, they all talk about how a particular Indian Contract Act defines all the agreements, categorizes these agreements as agreements which are or should be held to be void at all circumstances. So in such cases, if you see agreements which an agreement say to kill a bureaucrat or assassinate the head of the state is a particular agreement that has been entered into. However, it lacks legality of object, etc. But the fact is that explicitly there wouldn't be any contract, and even if there was, there would be nobody owning up to it. So in such cases, this is the act which qualifies as the same. So in the next chapter, we read about consideration, the legality of object and consideration. What exactly are these? So considerations could be past, as in past considerations could either be future considerations or it can be present considerations. Similarly, all sorts of consideration, whether they are past, future, or present, they all can be considered to be voidable or void, considering if there is an illegality of the object or consideration of such contracts. Now, when we are talking about when we are talking about what exactly constitutes consideration, we have a couple of things in our mind. Give me 1 second. Yeah. When we talk about consideration, we say that a consideration is what drives a particular contract. Consideration is what is the reason for which a particular contract, in most circumstances, will be entered into. Considerations can be at the desire of the promisor. It can also move from the promisee to any other person. If I go to a college and say that I want to get admitted, but I don't have the money. So in such cases, if my father is paying the money for me, so the consideration is being given by my father to my university, but the entire concept, the entire thing about the contract, it is being entered into by the university and me. Similarly, if I don't have the money to pay for something, supposing in capital market tradings, if I don't have the money to buy or sell shares, I can loan it. I can do margin trading. So in such cases, the money is actually being provided by my broker, but who's the owner? Who's the one who will be entering into the contract, the securities contract? It will be me at all points of time. So consideration is something that must be of some value. Unless it's a gift, unless it's a charity. The fact that a consideration needs to have some amount of value is a sine qua non. It may be an act or an abstinence or forbearance or a return promise. In addition to it, it can be something which could have been made in the past or present or in future. If, say, supposing a person had saved me from drowning, but said that I saved you from drowning because on a certain date you will help me financially for it. So the consideration for it, for my relations with this person in the future, will be based on a past consideration, which is a past act of kindness of saving me from drowning that he had done. It must not be unlawful in the sense that it cannot be something that is forbidden by law. I can't say that as a consideration I'll kill someone, or as a consideration I would go and blast a certain public space. So it cannot be fraudulent, cannot involve or imply injury to any person or property, or the court, if it regards such a consideration as immoral or opposed to public policy. Public policy is very relative. It's not something which is set in stone. It's not something that has been very conclusively determined by the judiciary, by the courts as such. But if something shocks the conscience of the society, which is to be decided by the courts itself, then in such case it will be opposed to the public policies. And if it is immoral or opposed to public policy, surely such a consideration will not be allowed, even if it is not categorically restricted by any law under the country, in the country. So there can be contracts which can be made without consideration also. If I make a promise on account of natural love and affection, if I ask someone to come and meet me on a certain place to go out for morning walks, and says the person, if he doesn't turn up, or supposing if I chose to go and do flood relief in a certain place, but now I want to come and ask for money instead, then such considerations will not be a part of any sort of agreement, and those agreements will not convert into a contract. Contracts of guarantee, agency, or remission, or completed gifts for that matter, they are all outside the purview of a contract, an agreement that can fructify as a contract. The next is regarding what exactly are these various kinds of promises. So you have privity of contract, which is the next topic. Now, every single time that there is a contract between two parties, what exactly is there for a third party who is not involved in the contract to bring in claims against the two parties who are in contract? Supposing if me and my neighbor fight sitting here in Calcutta based on a contract that we have clearly on behalf of my neighbor, or say for getting any sort of benefits, a third person sitting in the city of Bombay, or say somebody who's sitting in the city of Delhi, cannot come and file a claim against me or my neighbor to recover any sort of compensation for a breach of contract that has happened between the two of us. So the only exceptions to such cases can be with respect to the fact that a person, if he acts as a beneficiary of a trust. So supposing if a contract, if a share of a particular company has been bought for a minor by his guardian. So in such cases, the minor can bring in a claim even against the particular company who chooses not to give in dividends to the guardian of the minor, because it is an exception, because a minor is a beneficiary of a trust. The second is with respect to provision in marriage settlement. The third is with respect to provision for maintenance or marriage expenses of female members under a family arrangement, or assignee of a contract, acknowledgement of liability, or agency contract. So these are the various exceptions to a particular contract as and when it comes. What exactly is meant by capacity of the parties? Capacity of the parties is when we talk about section 11. The capacity of the parties is when both the parties have attained majority, if they are individuals, or it could be a legal person also, based on which that particular party would now be considered as a party which can enter into contracts. Now, there are certain exceptions to it also. Supposing if there are people who are temporarily of unsound mind, or say people who are majors but they do not have they do not possess a sound mind, or they cannot understand the consequences of a particular act, whether it's in a contract, whether it's outside of contract. The idea is that the capacity to contract is of utmost importance. Otherwise, it would be completely out of the number of mischiefs that can actually be propagated because of this will be innumerable. So if there is a child, a minor, who's below the age of 18, has absolutely no right to contract. In such cases, that particular minor, if at all, is driven, say, to take a loan or to take certain articles, goods or articles of consumption, which are not necessity based but are more luxurious based. So in such cases, to force the guardian and the father to pay for all of these imposed upon contracts will actually be held as illegal, and an exception to this sort of a contract so formed. So when we are talking about the disqualifications of persons, one of the first disqualification is that of an alien enemy. The second is with respect to foreign sovereign and ambassadors. The third is with respect to convicts. The fourth is with respect to insolvents. The fifth is respect to company or statutory bodies. The sixth is with respect to drunken or intoxicated persons. So if there is a lunatic who only who only becomes mad on a full moon night, so in such cases, that temporary unsoundness of mind could also incapacitate a person from being eligible to contract. However, when he returns to the normal sense, normal soundness of mind, he can very well be eligible to sign contracts or make promises or accept offers, because then he would understand the consequences of his act. The consent is of primary importance. Consent cannot be vitiated? Because if it is, it makes a particular contract voidable. What are the things that could vitiate a free consent? Coercion, undue influence, fraud, misrepresentation, mistake, or mistake as to the various laws or facts, etc. Now, every single time that you are concealing something, an act of concealment, you will be under a duty to speak, which if you don't follow, the idea would be that you have in fact misled or misrepresented a particular person, a particular thing. So if I am a landlord and if I know that there are certain defects in the particular house that I'm trying to sell, so if the tenant asks me if there are any defects in the house and I choose to keep silent, I choose to keep mum about it, in such cases, that particular contract uh, can be contested to be voidable. But it's very important that the person whose consent has been so vitiated brings forth the complaint. If there are two parties involved, a third party can't have a problem with the kind of dealings that is actually taking place within a particular contract. If I pay peanuts to a person wielding a gun over his head, saying that he should sell the particular land property to me, in such cases, a land property worth crores, if I have paid him only say 1 lakh or 2 lakhs rupees, a third party who is absolutely unrelated to the contract cannot bring a claim or prosecute me for doing what I did. So in such cases, the person who is aggrieved, whose consent has so been vitiated, is the appropriate person to bring in such claims. Section 15 has spoken about coercion, section 16 about undue influence, 17 about fraud, 18 about misrepresentation, 20, 21 and 22 about mistake. Now, silence does amount to a fraud. Silence only amounts to consent when in a contract, when there is a duty to, when silence is the only way that you can accept a particular contract. Similarly, with respect to fraud, if you have a duty to speak and yet you keep silent, in such cases, such silence would amount to a fraud. So when we talk about the quasi and contingent contracts, quasi contracts are those contracts which are imposed by law and does not arise by agreement, as well as the duty of a party and not the promise of any party is the basis of such contract. Supposing if there is a person who's lying after a car accident on the highway, suddenly there's a person who's a doctor, a renowned doctor who passes by and happens to see this person who's lying with a lot of wounds. So the doctor decides to help. Now, after the doctor has helped with the first aid, etc., of the particular person who was hurt, the person goes on to his house or he's admitted to the hospital by the doctor. And the doctor, after he has recovered, the doctor sends him a nominal bill of the first aid that he has in fact performed. Now, this sort of a contract, although there was no proper offer or an acceptance or there was no consideration negotiated, nothing, it would still be a contract. Why? Because this is on a good faith principle that a person who has helped you in the times of need should also be reimbursed for the damages suffered by him. And that is what we would understand as a quasi contract. A contract which has not been entered, but a sort of transaction or relationship that closely resembles a contract. So this is what a quasi contract is. Now, there are many types of quasi contracts. Claims for necessities supplied to a person incompetent to contract. If supposing there is a little boy who's of 8 years has been left in the house without food for days on end because the father is out of station, couldn't come back because of extremely bad weather conditions. The nearby grocery shop decides to give him some supplies of food, but in return asks for money from the father when the father comes back for feeding the child. So, in such cases, there would be a quasi contract between the father and the grocery shop owner who has supplied the particular boy with food when he required it. That's a quasi contract. And there are many kinds of quasi contract. On the other hand, what we mean by a contingent contract is something which is based on the happening of a certain event, which may or may not take place. So, an absolute contract is basically when there is no qualification as such. I will sell you the book, you will pay me 100 rupees. But if I say I'll sell you the book only when, for 100 rupees, only when a certain person dies. Now, the contingency of death, it could be today, it could be 10 days from now, it could be 10 years from now, it could be, I don't 20 years from now, it could be many things. So, this is a contingency where there's no responsibility on one of the parties to decide as to when the contract may come into place. Similarly, if I say that I will pay you in an insurance contract, I will pay you 500 rupees provided your house burns down. In such cases, it would mean that the contingent event of your house burning down may not happen. But if it does, I'm going to pay you. So that's a contingent contract. So when we are talking about contingency is something that does not vitiate a contract, provided that such enforcement is done accordingly. So there are provisions in the Contract Act which enforces a contingent contract. Section 32, Section 33, 34, 35 and 36. But if there are impossible events, supposing if I say that I will only pay you a certain amount of money provided that cows fly. So this is an impossible event and for which the agreement will not be enforceable. It will be void. What exactly is meant by performance of contracts? Performance of contracts is basically with respect to what we understand as the obligations of the parties. What are the obligations of parties in a particular contract? The effect of refusal to accept offer of performance. So you talk about obligations of parties under Section 37, whereas Section 38, Section 39 talks about effect of refusal to accept the offer, effect or refusal of a party to perform a promise, and so on and so forth. Now, performance is at the very core of every contract. Without performance, there can never be a contract. So that particular performance, once it is done, will give rise to any sort of compensations that can be paid at a later point of time. So in such cases, if the performance is something which can be vitiated before it is performed, supposing if a person has said that there would be a delivery of goods and there would be a payment of a certain rupees, but the person who was supposed to deliver the goods dies on a particular day, then there becomes an impossibility of performance. So in such cases, the representatives of A is supposed to deliver the goods as well as B is supposed to make the payment. Now, they can either perform or offer to perform their respective promises unless such performance is dispensed with or excused under the provisions of this act of any other law. So that is according to section 37. And section 38 talks about whether a promiser has made an offer of performance to the promisee and the offer has not been accepted, the promiser is not responsible for non-performance, nor does he thereby lose his right under the contract. So every such offer has to fulfill the conditions such as the fact that the performance has to be unconditional. In addition to it, it must be made at a proper time and place, and it should be an offer to deliver anything to the promisee, which there would be a reasonable opportunity of seeing that the thing offered is the thing which the promiser is bound by his promise to deliver. So there are various ways in which you can calibrate a performance. Who has performed it? How many people have performed it? What happens if one of them chooses a way out? What is the time and place of performance? Whereas what is the time specified or the place specified for that particular performance to happen? With respect to the manner of performance, the fact that it should be reciprocal, or what sort of order should it follow, who performs the act first, the liability of the parties who do not want the performance to take place, the effect of default of such a promise, and the legality or the illegality of the promises that have been made. So there are multiple ways in which you can talk about promises and how promises may or may not stand in such cases. And time is the essence of contract. So reasonability of a contract acceptance is something that is determined even by time. If, say, through influx of time, there is a certain acceptance that you have not made, the same acceptance can't be done after the lapse of a considerable period of time. So in such cases, the offer is liable to expire. Even if the expiry date of such an offer has not been mentioned, the fact that expiry of offers do happen can be determined by the judiciary at a later point of time. So the offerer can't be made liable for having revoked his offer after a reasonable amount of time. So effect of such failure when time is not essential, and the fact that effect of acceptance of performance at the time that other than whatever is agreed upon. So in such cases, the appropriation of payments as well as appropriation of the performance of the kind of the contract that is in place, that would also depend on the time of the performance. The next topic that we would be dealing with is that of indemnity, guarantee, pledge, and agency, whereby we are going to look at the various concepts which is a part of special contracts in the contract law, and eventually we talk about e-contracts and e-signatures and discharge of contracts, how exactly the contracts would be said to have concluded, whether it is by performance or by lapse of time. This is what we were talking about, time being the essence of contract, either by death, insolvency, or unauthorized alterations, or say mergers or change in law for that matter, or impossibility of performance or breach of contract, It could be either through novation of the contract, alternation or recession, remission or waiver of the particular contract. Determined on the basis of the kind of performance. And finally, we talk about breach of contract and remedies to those breaches. What happens if a particular party says that they don't want to perform their part of the contract? However, we have a law that determines the specific performance of the parties, whereby the party is asked to perform instead of paying any damages for the breach of contract that they may have caused due to their non-performance. And there are corresponding remedies also for such a breach of contract. Quantum merit being the amount of work, the amount of damages that you need to pay for the amount of work that is done, and technically for all others. So when we are talking about the various kinds of concepts relating to contracts, we are supposed to be very mindful of the fact as to what constitutes the body of contract and how exactly are these contracts supposed to be undertaken. And then we move forward with sale of goods with respect to what do we mean by goods as well as what we mean by sale, a contract for sale. This is a more specialized contract that we would be talking about. So this is all for today's class, and we will be talking about the remaining in the next class, in the next session. Thank you. If there are any questions, I will be able to take them. Are there questions? Considering according to my clock, there are 10 minutes that is left out of the 2 hours class. So I would like to take, yeah, there are questions, I think. Are there any questions? Section 34, did someone want, okay, privity of contract and section 34. Let's discuss these two things before we end the class. Privity of contract.
Just
Yeah.
give me a moment. I'm checking with the question. You can carry on with the class.
Yeah, there are two questions that I want to address within the questions only. One is about privity of contract. When we are talking about privity of contract, basically we are talking about two parties who are supposed to be in a contract, only they can bring claims against each other. If I have a contract with you, I have to have a particular uh, uh, obligation, or I will have a particular performance to do for my part of the contract. If I say that I want to sell my book to you for 100 rupees, the book will be sold by me and you will have to pay me 100 rupees. So if I sell my book to you for say 80 rupees, in such cases, a third party can't come and claim that please do not sell the book for 80 rupees because it is supposed to be for 100 rupees. There is no claim unless the party to whom I've sold the contract has a claim for it. The fact that when we are talking about two parties, this actually happened with a particular case, which let me explain the case. Donoghue versus Stevenson was a case whereby a couple went, Mrs. Donoghue and Mr. Donoghue, they went to a hotel and said that they wanted a bottle of ginger ale. Ginger ale is a kind of a drink, and they went to a restaurant for that. Now, the ginger ale is something that is not manufactured by that particular restaurant or the hotel. The ginger ale was actually given to them in a sealed bottle, which was prepared by a third party manufacturer. That particular bottle, when it was given for their consumption, that particular bottle, after having drunk nearly 3/4 of the bottle, they found out that there was a snail, a rotten dead snail at the end, at the bottom of the bottle. That particular snail, when it was extracted, Mrs. Donoghue said that having drunk that particular bottle of ginger ale, which was so badly made because it had a rotten dead snail at the bottom of the bottle, she felt sick and she wanted compensation. Now, when she went to ask for the compensation from the restaurant owner said that they were not the manufacturers of the bottle, so they will not be liable for it. So they went and asked who is the manufacturer of the bottle, and they found out that it was a factory close by. So they went to the factory and said that who is the owner of this factory. So there was another person who came, Mr. Stevenson, saying that I am the manufacturer of this bottle. This factory belongs to me. And what do you have to say? So Mrs. Donoghue said that your bottle of alcohol had, or your bottle of drink had a rotten dead snail, and I want compensation because that is not supposed to be there. But Mr. Stevenson said that I'm not supposed to pay you because my duty or duty of care, my obligations are with respect to the restaurant owner with whom I have a contract to sell my bottles of drinks. So in such cases, I will take no blame for the kind of damages that you have suffered as a customer of that particular hotel. So Donoghue versus Stevenson was a very leading case, is a very leading case till date for the fact that contracts have a privity in between. Privity of contract means that only the parties to a contract can sue each other for the performance, breach of performance, lack of performance, shortcomings in any performance of a particular contract. And no other third party can do so. So this is what the entire concept of Donoghue versus Stevenson, or the privity of contract, talks about. Now, Indian Contract Act Section 34. I hope this is clear. Section 34 talks about when an event on which contract is contingent is deemed impossible if it is the future conduct of a living person. If the future event on which a contract is contingent is the way in which a person will act at an unspecified time, the event shall be considered to become impossible when such person does anything which renders it impossible that he should so act within any definite time or otherwise than under further contingencies. Marriage is a kind of contract. Marriage could be something. Marriage is something which could be certain. So if I say that on a particular day, date and time, if a person is going to marry, because that is within the control of the parties, they will pay a certain amount of money. One person will pay to the other person. So that is completely understandable. But when we talk about, say, the death of a person is something which is not in the hands of anybody. So in such cases, if a person, if I say that I'm going to pay you 1,000 rupees only when a certain person dies, so that is an absolutely contingent contract. Definitely it is. However, the time lapse from today till the time that the person dies, it's an uncertain period of time. So I don't know when I'm going to pay you. You don't know when the payment is going to come. So it's a very unspecified, uncertain period of time. So in such cases, such contingent contracts cannot be enforceable because those have no certainty of time whatsoever, or the fact that performance has to take place on a certain, on a designated date or time, etc. Even though death is certain. There can be certain contingencies involved, which may just be impossible in future. If you take those into account, then it becomes even more difficult. So this is what is meant by contingency of contracts, and there are very many ways in which we can explain it, and how we can talk about the impossibility of performance, provided the object is no longer in question. If I say that if this building burns down, I'm going to pay you 500 rupees. What is the building has been raised off? The building has been demolished. So clearly the contingency doesn't arise because there wouldn't be any fire because there is no building. And then in such cases, I will not have any sort of obligation to pay you the 500 rupees. So impossibility of performance can arise at many stages, even in normal contracts, not just in contingent contracts, but in contingent contracts, because it talks about a future event which may not happen. The chances of the frustration of the object not being there, frustration of the object, of a frustration of the purpose being there, is higher as opposed to other contracts. So if I say that I contract with you for 10 kgs of mangoes, if I say that I want to buy jams from you, mango jams from you, but you say that the mango jams would only be made if at all I have 100 kgs of mangoes. But there was no harvest for mangoes this year. So in such cases, the person will not be able to make a jam, and the contracts as such, which he has made with his clients, will not be fulfilled. Because the entire event, the give and take, the buy and sell of the mango jams was contingent on the fact that there would be a harvest of mangoes, and the mangoes would then be taken by the factory owner to make jams. So if there are no mangoes in question, there wouldn't be any jams and there wouldn't be any contract of sale. If there are any more questions, I'll be willing to take them. Quantum merit. Quantum merit is a concept whereby if you have performed, supposing the contract is to take you from Delhi to Kolkata by a train. But supposing if I say that I have taken you from Delhi by a train, but I drop you off at Lucknow, I don't bring you all the way to Calcutta. So in such cases, I have not fulfilled the entire part of the contract, but only a part of it. So that's quantum merit. Because the compensation, even if the contract has not been fulfilled, even if there has been a breach, maybe there were damages that were faced by you because you had to make your own way from Lucknow to Calcutta all by yourself. The fact that from Delhi to Lucknow, how would you reach if the carriage in question was missing? The fact that you have been given the benefit of travel from Delhi to Lucknow, even if it is a partial fulfillment of the contract, certain expenditures, damages have to be paid for that. So quantum merit is basically the concept where they say that even for part performance of the contract, a certain amount needs to be paid. And thereafter, for rescission of the contract, you can pay. Supposing there is an ongoing, there's another example. There's an ongoing contract between an Indian company and a Pakistan company, and a continuing contract where they buy and sell sugar. So in such cases, sugar will be used. Sugar will be sold by Pakistan, and India would be buying it. Now, if there is a buy and sell of sugar, in such cases, what happens is a part performance of the contract. Supposing I require 12 bags of sugar, one each every month. But supposing by the month of September, from January to December, but by the month of September, there's a war between India and Pakistan, and obviously Pakistan became an alien enemy. So in such cases, all the contracts between India and Pakistan becomes void, because between warring nations, the contract's enforceabilities are usually suspended. So in such cases, if I don't give you any bags of the contract, would you not pay me for the amount of bags of sugars that I have in fact bought or sold to you? So if India is selling sugar to Pakistan, Pakistan is supposed to make the payment for at least those 6 months or 9 months that they have actually bought the sugar packets from India. Even if India was unable to send sugar packets for the last 3 months or the last 6 months. So that is the whole concept of quantum merit. You pay for the amount of performance that there has been in a contract. You may not pay for the rest because it has not been made. You can ask for damages for the remaining because the contract has been breached in between. You can ask for specific performance of the contract if you don't prefer damages because you want the performance to be done instead of damages because that counts much more to you. But the fact is that quantum merit means that you need to give the amount of money for the amount of for the amount of performance, even if it is part or quarter performance that you have made of that particular contract. So this is technically the concept of quantum merit and technically the concept of privity of contract. If there are any more questions, I'll be happy to take them. Abstain. Simran has asked a question on abstain. Abstain means you stop from doing something. Abstinence, refrain from doing. You do your abstain. I ask you, I say that I tell you that please go to the class and I'll pay you 100 rupees. So you have to do something. You have to go to the class. But if I say don't go to the class and I will pay you 100 rupees, so you have to not go to the class. Whether you push the brake, that's committing. When you're not pushing the brake, you're abstaining, you're refraining, you're stopping, you're omitting to push the brake. So that's what abstain means. So the contract could be to do or not to do something. So to not do also you get paid for certain contracts. So that is abstinence and that could very well be a part of a contract. I'm talking about all the concepts. Sanjeev sir, if there are more questions, if you can tell me.
Ma'am, just give me a moment. We are checking the questions.
There's one another question that I'll deal with in between, that is consideration. Consideration means what are you giving me for the promise that I have made? Suit for injunction means to injunction is a order that is given by a court to stop something for a temporary time being. So a suit for injunction is when you are seeking to stop something. Supposing if there is a general meeting in a company that has taken place, which says that the company will sell shares to private investors instead of selling it off to the public. Public offer से नहीं sell करेंगे shares. We are going to sell it to 5 or 10 people at a time. So you go, because you don't want that, you want a public offer that the company should perform. So you go to the court and you file a suit for injunction, whereby if the court gives an injunction, the court can stop the company from selling the shares altogether. So that's a temporary relief. An injunction is always a temporary relief that can be granted by a court upon an application if it thinks fit under the Civil Procedure Code. But a suit for injunction can be done even with respect to contract, where you can stop, the court can stop the performance of a further performance of a particular contract or some sort of an obligation. Consideration was a question that they had asked before. Somebody had asked before, Simran, I think. Consideration is basically what is it that you're giving me. If I give you a book, you are supposed to pay me 100 rupees. Your 100 rupees is the consideration for me. Whereas you're paying the 100 rupees for what? You're paying it for the book. So the book that I'm going to sell you, that particular book is the consideration for the 100 rupees that you're giving me. So that is give or take. Consideration is what forms the encouragement for me to perform my part of the promise, and consideration for you will be the encouragement for you to perform your obligation. It's what you're getting in return is what we mean by consideration. So consideration could be past, future. 10 साल पहले आपने किसी को बचाया था from drowning, that can also be a consideration for you to do some work for somebody today. या फिर I am doing something for you today so that after 10 years you are going to repay me for this. So that's a consideration which is sort of a future consideration which you will be paid, a deferred consideration. So consideration could be either past, present, or future. A deferred, an executory consideration, what we say for a future consideration. After accepting the offer, if the person dies, usually the representatives are the ones who are supposed to perform the part of the particular contract. But if the particular contract, if the particular contract had to be performed by this person, say supposing I buy a book from you, I have to pay you 1000 rupees. But before I could pay you 1000 rupees, I die. But I have already got the book. Now the problem is that my entire money, a dead person can't hold a bank account. It always devolves into his heirs, legal heirs. So if there is a legal heir that is in place, so in such cases, my money will then be divided between the legal heirs, and then it would be divided amongst the creditors to whom I owe the money to. So it depends. What exactly do we mean by the fact that a person has died before accepting the offers? If representatives can't perform, then it becomes difficult as such. A substituted agent, we are going to talk about the principles of agency in the next class, but a substituted agent is whereby there is an agent and a principal relationship between two people. The idea is that an agent is that person who can enter into contracts on behalf of the principal and make the principal as liable with respect to the contract that he has entered into, as though the principal has entered into the contracts by himself. So a substituted agent, if there is somebody else, say a sub-agent that has been appointed, supposing Xiaomi is a Chinese telephone company. Xiaomi is not coming to India to sell its phones, but Xiaomi has chosen a distributor in India. So in such cases, that particular agent, the agency, will sell Xiaomi phones. But supposing the distributor is not located in a certain area, so that distributor can have a sub-agent who can then sell Xiaomi phones in those areas where he's not available. So agent in the sense that if Xiaomi says that I can offer discounts of 10% on my goods, the agent can only offer discounts up until 10% on the goods of Xiaomi and no more than that, because that is what the principal has asked. So an agent is supposed to be instructed by the principal, but an agency selling the phones to you is as good as Xiaomi selling the phones to you. So if you have any sort of court cases, that will be against Xiaomi and not against the agent. So we are going to talk about principal and agent theory. If there are no legal heirs as such, then whoever is a nominee of that particular bank account is the one which is going to decide as to how much money is to be paid to the creditors. It depends. There's interstate succession and testamentary succession that is a part of your family law, which you don't have to read because you are CA students, so CMA students, so you have your commercial laws. But when we read about personal laws, Hindu laws, Muslim laws, etc., you'll actually find how exactly the distribution of property is done. Intestate is when you die without a will. Testamentary succession is when you die with a will. So if the people who are supposed to get your assets or get your property by means of a will, they are the ones who have to decide whom to pay, whom not to pay, how many creditors need to get how much money. And intestate is when you die without a will. So that's based on the kind of school. Daya Bhaga, Mitakshara. There are many family law schools, personal law schools, depending on that. You'll get it. It is based on personal laws, whether it's a Hindu who's dying or a Muslim who's dying, etc. Non-gratuitous is basically something that is on payment. Gratuity means for free. So non-gratuitous means on payment. You have to pay for something. So cases are not mandatory because you will not be asked cases, but do be very aware of the provisions because provisions are very important and you need to learn the provisions. Learning sections is very easy because you have to only grab a bare act and you have to learn the sections. And the sections are written in the bare act. You can even download it. It's open access from indiacode.nic.in. You can even get it from there, or you can get it from Ministry of Corporate Affairs website. You can get it from Ministry of Finance's website. There are multiple bare acts that are there. Find out which has the authentic Indian Contract Act. If you can download it, you can see the sections and you can memorize the sections. So it wouldn't be very difficult for you. So this is basically what the premise of your conceptual understanding till now for contracts is. In the next class, we are going to deal with principal agent relationship. We are going to talk about what we mean by agents, sub-agents, and how exactly are the contracts executed and what happens upon a breach or how discharge of contracts takes place. We are going to talk about bailment and agency in the next class. Bailment, there are many kinds of bailment. It's basically what you do with your car and the garage. That's an example of bailment. I give my car to the garage to work or to be serviced upon. So that is a contract of bailment. When I have given my car, so I am the bailer and the garage owner is the bailee, and then there are obligations. How is he supposed to keep my car? What exactly can he do or cannot do with my car? What time period should he keep my car with him? How exactly am I supposed to pay him? For what services am I supposed to pay him? What can I hold him liable for? So bailment is what we will understand based on that. Section numbers are compulsory to learn, as I understand from your CMA question papers, unless the amended version has something else in it. Okay. So, Sanjeev sir, would that be all or? Are there any more questions you can ask? I think we'll possibly be having our next class after a few days. Okay. Okay. Thank you so much. I'll see you in the next class.
Thank you, ma'am, for today's session.
Thank you, sir.